Good afternoon, Justice Savage.
Good afternoon, Chief Justice. How are you?
I must apologize that we kept you waiting for, 3 hours?
Not a problem at all.
But that's the nature of the game, but that still doesn't make it right. So do forgive us, please. I must first place on record that you were not particularly keen, and perhaps that's an understatement. You were not so keen on applying for this position. And were it not for the fact that you were asked by a number of colleagues, including this one, you would not be sitting there. And I just want to thank you for coming here today. Yeah.
Thank you, Chief Justice.
All right. You have how many degrees under your belt? 3.
I have 3 degrees, yes.
A BA, LLB, and LLM, summa cum laude.
That's correct.
LLM obtained from the University of Notre Dame in Indiana, US, of A, and the others from the University of Cape Town.
At the University of Cape Town, yes.
All right. Your legal career starts in 1992 when you did your articles at Channel's Albertine. Was that in Cape Town?
It's in Stellenbosch.
Stellenbosch,
yes.
All right.
I had chosen that firm because I wanted to do basically political work. That was the reason I'd done law.
Yeah. And that is evidenced by what you did thereafter. You worked at the IEC, but then went to Parliament. What did you do in Parliament?
I was working for the ANC's Constitutional Commission in Parliament during the final negotiations towards the Constitution. So I reported to President Ramaphosa. I was the person who kept the list of all of the issues that needed to be negotiated with the National Party and with the Democratic Party. And I attended all of the bilateral and trilateral negotiations held offline between the political parties with the list of issues that needed to be resolved. And as they got reduced, the issues became narrower and narrower. We came to the end of the process. And we were left then, as everyone knows, with 3 issues, and that was the 3 issues in the Bill of Rights, which we spent some time negotiating. And then almost at the end of the whole process, President Ramaphosa said to me, "But where's the preamble?" And I said, "I don't know." And so what I did was I went and looked at all of the proposals of all of the parties, made a document, drew up what the different parties' proposals were, and then met with Joel Netshitenzhe in the presidency. And he and I then worked on the preamble, and I basically came up with the idea that we would use verbs to say where we were coming from, and then verbs in the preamble to determine where we were going to, so that we would, as the people, recognize the injustices of our past, honor, respect, believe, and then move towards healing and establishing, laying the foundation for a democratic and open society, and then improving the quality of life of all citizens. That then was, and building a united and democratic South Africa. That was then what we came up with, and it was left pretty intact. Joel Netshitenzhe is a very gifted writer, and it was a very easy process. I'd done a draft. He and I sat on a couch in the presidency, and we really worked on it together. And then the only issue that stood out afterwards, to the extent that the commissioners are interested, is that there was a very strong belief that we should make reference to God in the preamble. And so what I suggested to the National Party person I was liaising with was that we use the national anthem and make reference to that at the end of the preamble. And that's how we came to the preamble. So that's just one of the clauses I was involved in.
I didn't know this. You don't talk about it at all.
No, I don't.
So, in a word, you are one of the midwives of the Constitution.
Yes, in many ways, yes.
Yeah.
But there are a lot of those, a lot of midwives.
Of course. Yeah, that's pretty impressive. Okay. So, after that monumental work, you joined the LRC, the Constitutional Litigation Unit.
Yes, I was then involved in the certification of the Constitution. So at the LRC's Constitutional Litigation Unit, I was an attorney, and at that stage I was involved in that phase of the certification proceedings and then in other of the early litigation in the Constitutional Court.
All right. That was until
That was
1997.
Yeah, I had broken my master's degree, much to the dissatisfaction of my father, who was an academic and thought such things were utterly unacceptable. And I'd come back to work for the ANC in Parliament, and then I had, after that, decided I needed to finish my degree, so I left the LRC to finish my degree and came back for a short while.
All right. But then you left all that exciting stuff and went to the CCMA. I'm not saying it's not exciting work.
I started arbitrating actually, and while I was at the LRC, I started arbitrating, and in a way, I had a bug. I was bitten by that bug, and I quite enjoyed adjudication. And then I was phoned one day and asked by somebody looking to employ people at the CCMA whether I wouldn't be interested, and I said no, I didn't think so, but they said come along for an interview, and it sounded like I'd do a lot more arbitration, and I was quite keen at that stage in getting into arbitration, which I hadn't previously. It gave me an opportunity to get into essentially decision making, and I was quite keen on that as an area of law. I'd also wanted, by the way, to be a soccer referee, but I was told that women couldn't be soccer referees because during my time at university, I was involved in non-racial sport through Satisco and so on. Yeah.
All right. Well, you leave before your time, ma'am. Okay. Then you started your own law firm in your own account.
That's correct.
For 5 years.
That's correct.
What happened in 2005?
In 2005,
you became partner at a certain law firm.
I think at that stage I went to Bowman's, did I? Yes, I went to Bowman's.
No. Before Bowman's.
I then joined, I'm forgetting my own CV.
You became a partner at a certain law firm, and I'm trying to figure out if was that with your husband?
That was with my husband, yes.
Uh-huh.
So that was with my husband, and then then I left that and went to my
to Bowman's.
To Bowman's, and I was then in their public law and employment law area.
And you were director there for a few years.
Yes, I was.
Then you appeared to have returned to your law firm with your husband for a brief spell, but you became appointed as a judge.
Yes, I then was acting. I acted in the Labour Court in Joburg in 2011, and then in 2012, and from 2012, I have pretty much consistently been in the High Court. So I was acting as a judge in the High Court, and then applied in 2013, and my colleague and friend, Judge Bokwana, was appointed, and then I was asked if I didn't want to be in the Labour Court, and decided not. I'd prefer to stick around and apply for the High Court if there was a position available thereafter. And in 2014, I came before the JSC again, and was at that stage then I applied for the High Court, and I was appointed following that interview in 2014.
And then you made your way up to the Labour Appeal Court, in the Labour Courts.
Yes, I acted
by 2023.
Yes, I'd acted for 23 terms in the Labour Appeal Court from 2015 until my interview in 2023. Mm-hmm. Yeah. And then I was appointed to the Labour Appeal Court with effect from 2024. Perhaps I've got the date. I might have the dates wrong.
Yeah, in 2024, you acted there.
Yeah.
So I've been until very recently, until your stint at the Constitutional Court started, not so?
That's correct.
Just now?
That is correct. I started at the Constitutional Court from the 1st of June.
Yes. All right. So, but before that, you had a longish stint at the Competition Appeal Court.
I was acting. I didn't do very many cases, and I haven't written a judgment. And I then also acted in the Supreme Court of Appeal in 2022.
All right. You were at the Competition Appeal Court for 3 terms. How did it come about that you couldn't get a single judgment to write?
I don't know.
didn't
I think it
happen.
might have also been that I was busy with the LAC and
Yeah.
had obligations in the Western Cape, and so it's as an appeal court you kind of fit that work in. So it could have been something
Yeah.
to do with that.
Then in 2024, last year, you acted as the deputy judge president at the LCs, the labor courts.
Yeah, I was the Labour courts. I was the deputy judge president for the whole of last year. I acted in that position, and then I acted as judge president for the
For how long?
first term of this year.
Uh-huh. And then we asked to bring you over before the court was ready to release you.
Yes, that's right.
All
Then
right.
I started at the Constitutional Court. Yeah.
How have you been finding your time at the Constitutional Court?
It's been very stimulating. I've enjoyed it a lot. It's a lot of work, but it's really very interesting work, and it's right up my street.
Yeah, that's what I thought. You seem to be reveling in the whole thing that drags some of us down. All right. You have written many judgments in your lifespan as a judge. Has it been 13 years?
Yeah,
Yeah.
that's
Uh-huh.
correct. From 2012, I've been writing judgments. Yeah.
How many would you say you have in your pocket?
I think there's something like 220 on SAFLI or 215 on SAFLI, and then there are, of course, all the criminal appeals and reviews and criminal trials that are not obviously on SAFLI either.
Yeah, that are not reported on. Mm. Well, in addition to all this work and the administrative experience you have from having acted in the leadership positions of the judiciary, there are other administrative leadership positions and administrative positions that you've held in other extrajudicial bodies. Um, you were a trustee of the Constitutional Court Trust for a long time.
Yes, I was. That's correct.
And a member of the Hemophilia Foundation of South Africa since 2001.
Excuse me, I missed that.
Sorry?
I missed the question. Please, I couldn't hear it.
Oh,
Sorry.
it says here, member Hemophilia Foundation of South Africa.
Yes. I have 2 children who have hemophilia, which is a bleeding disorder.
All right.
Yes.
And more related to our work, you have long involvement with SAFLI, the Southern African Legal Information Institute. What exactly have you been doing there?
Yeah. I mean, I think with Judge Katharine, the two of us have really been the driving force behind SAFLI. I mean, we took it over from Wits, and it's very little. It was an infant organization of nothing, with a few judgments, and we had it based at the Constitutional Court in the library with the help of Cheryl Latuli, and it was a project of the Constitutional Court Trust, and we built it up into what it is today over a period of 20 years, getting the IT tech support that we needed, getting the staff employed that we needed, building the relationships with the courts around the country, and really trying to ensure that everybody, all of us, as South Africans, as non-South Africans, as students, as members of the public, have access to judgments, access to law, access increasingly, we hope, to legislation, and we'd like to see more journals. At the moment, I'm the board chair of SAFLI.
Yeah.
And then I've also been on the United Nations Appeals Tribunal. I was appointed in 2022 I was elected by the General Assembly. I was asked to apply, wrote an exam, and then was elected by the General Assembly onto the United Nations Appeals Tribunal.
So what kind of work goes on there?
It's essentially an employment tribunal within the UN system, so it's their labour appeal court, and they were looking for women. They're short of women around the world in this kind of capacity with those kinds of skills, and there is no other woman from Africa on the court, and there has not been previously on the court, and there are 7 judges from around the world who serve on the court on an ad hoc basis.
All right. You also have quite a few publications to your name.
Not as many as I would have hoped, but I have had 3 kids and tried to be an active parent.
Yeah, I'm just trying to figure out in my head how you managed to do all this, write the number of judgments you've written, and do everything else, and still produce not judgments, articles in accredited publications.
I think some of those were really before I actually had 3 kids. They might have been when I had 1 child.
Yeah. All right. Uh, I think I'll stop there, Justice Savage, and let my colleagues put questions to you, starting with President Molemela.
Good afternoon, Justice Savage.
Good afternoon, President.
How are you?
Very well, and yourself?
I'm well, thank you very
Good.
much. My first question pertains to the provisions of Section 174(2), which states the need for the judiciary to reflect broadly the racial and gender composition of South Africa. And my question to you, no right or wrong answer, but I want you to motivate your answer either way, whether you think it is essential for the Constitutional Court in particular, as the apex court, to have gender parity on its bench.
Without a doubt. I think that women bring a completely new and different perspective to the area, to the judiciary, and to the task of judging. I think it's very important for teams of judges as they sit in benches in appeal courts to be diverse, that there are different perspectives that are brought to bear when diverse people sit together. And I think it would be an amazing feat if this court were to be the first national apex court that, like the SCA, reflected a very strong gender representativity. The Constitutional Court were to become the first national apex court in the world to have a majority of women.
And my second question pertains to 167(3), I think it's 2, B2 of the Constitution, which gave the Constitutional Court general jurisdiction. Do you want to tell us a bit about the provisions, about the general jurisdiction of the Constitutional Court, and in particular, under what circumstances would it not be in the interest of justice for that court to entertain a matter that raises an arguable point of law that is of general public importance?
The difficulty that I have with this section, and it's a difficulty that I've experienced while being at the court, is that an arguable point of law of general public importance can almost be everything and anything. There is really only the mundane areas that don't fall within that category. And so it does seem to be posing, in my limited experience of the course, some difficulty as to what cases should, in fact, what leaves to appeal should be granted and which should not be. I also think that it's posing some difficulties in relation to the role of the specialist tribunals. So, President Molemela, you were, I think, the 3rd woman, or perhaps even the 2nd woman appointed to the Labour Appeal Court. And you will know that acutely that what the role of the Labour Appeal Court is. And increasingly we're seeing a leave to appeal granted to the Constitutional Court on issues that arise out of the areas of these these courts of specialist jurisdiction, that is causing some consternation certainly in the labour fraternity as to what matters are coming before the court and why. That there needs to be some greater thought given to what is a matter that falls within this definition of 167(3)(b), because otherwise it's really just up to a sort of luck of the draw situation that somebody once applied, didn't get leave, and then a year later somebody else applies and on precisely the same issue gets leave. And I think those are some of the difficulties that are arising. I've certainly found it quite difficult to ascertain on what principled basis the court is proceeding to grant leave to appeal in this area. And I think it's an area that needs further clarification. I also think, finally, just that the role of the SCA, like and of course quite different to the specialist tribunals, to specialist courts, is that the role of the SCA is an important one, and that it has over the years developed the law it's got a far greater number of judges in important areas, a wide spectrum of the law, and that we shouldn't very quickly be intervening where we don't need to as the Constitutional Court in issues that can be left at the level of the SCA or the LAC or the CAC.
Thank you, Justice Savage. Thank you, CJ.
Thank you very much, CJ. Good afternoon, Judge Savage.
Good afternoon, Professor.
I came across one of your judgments that I think stood the test of time. It was a minority judgment.
It was, excuse me, I couldn't hear?
It was a minority judgment.
Oh, yes.
It is the judgment of National Union of Metal Workers of South Africa versus Dunlop. It subsequently found itself in the Constitutional Court.
That's correct.
In that judgment, that judgment rather dealt with the concept of derivative misconduct. And you deviated from what the majority judgment at the time tried to encapsulate what this particular phrase should be understood as in the context of collective wrongdoing, in the context of a strike. I just want to find out as to what is your sense of the development of this derivative misconduct in South Africa, and whether the manner in which the Constitutional Court, if to the extent to which you might remember, has done justice to where perhaps your minority judgment wanted to take the concept?
I would think it has, because I think increasingly we're not seeing derivative misconduct cases easily coming through. That what we're seeing really is cases where there's direct evidence of misconduct, but that this notion that you must have some obligation to rat on your fellow employees and tell on them to your employer is in our country, I think, a complicated notion and doesn't take, as I tried to canvass in my minority judgment, doesn't take account of the situations under which people live. It doesn't take the workplace and the complex dynamics of our workplaces into account, and it doesn't deal with issues of danger for particularly female employees, which in this case was exactly the point that you were asking female employees living in a violent situation, in a very dysfunctional and violent strike, to come up and, as my colleagues would have had it, and I'm friends with all my colleagues, so they won't take offense to me referring to this, but rat on other employees, because I simply couldn't agree with that. I mean, I've tended to take the view that where I have a principled difference, I will dissent. And I've done that meaningfully, I think, in that case, and I think it has put paid to this unruly horse of derivative misconduct, I hope.
No, it was a powerful dissent. And one perhaps hoped that when you're going to, should you be successful, you'll continue to dissent where there is a need, because it appears to me that most of the judgments that are coming out of late in the Constitutional Court, they are more on a consensus base, and for me it's quite worrying. But nonetheless, I want to ask you about something. I'm not sure if you were sitting on the panel that dealt with the competition law case.
Yes, at the Constitutional Court,
yes.
I was.
Before that case was heard, there is a pension law death benefit case that was delivered by the Constitutional Court. Mutsila.
Yes.
And what appeared in Mutsila, you found that the Constitutional Court was able to overturn Goneri that was delivered by the Supreme Court of Appeal on how death benefits should actually be dealt with, because Goneri was saying you need to determine at the time when the member actually, when the fund is actually making the distribution of death benefit. And now the new position is that you need to do that at the time when the member actually dies. But what came out was, under what circumstances would the Constitutional Court or any other court overturn a decision of a lower court even though that particular decision is not necessarily before the court. In other words, you don't have an appeal from that particular case. You are dealing with a completely different case. But it so happens that the, the principle that was enunciated in that particular case is found to be absolutely wrong. And now the court is faced with a position whereby it needs to charter a different view. What motivates that? What are the parameters of actually overturning a judgment that you are not actually dealing with?
Well, I mean, I wasn't in the panel in Mozilla, and I haven't looked at it that carefully, but I would have some reservations. And my reservations, just hearing you, Prof, is that we bind the parties to their pleadings. We say that you can't come along to court and present a case completely different to the case that you pleaded, even if you suddenly wake up at the 11th hour and realize that you've got a great point that you should bring. And I'm not necessarily sure that courts shouldn't be bound by that same rule. Is that we should decide what's before us, unless we're going to take quite a different approach to judging and the process of judging and call for submissions on cases that we decide are important to hear. So I haven't looked at it. It's subject to the qualification of Mozilla. I haven't looked at it I did look at it during the course of the hearing very briefly because a reference was made to it on SAFLI, but then I haven't actually engaged with it carefully. But I would think it's an area that I'd have some caution, certainly from my perspective, as to how we should deal with these issues. I'm, by the way, not necessarily averse to the court expanding how cases come to it, because I think sometimes we're very hamstrung by the fact that we are only hearing those cases that are brought to us. And if you look at other jurisdictions, and I might be considered to be being way out and saying, like the epistolary jurisdiction in the Indian Supreme Court, where the court can say on pavement dwellers or something else, that this is the type of issue we should be deciding, and then call for submissions on that issue. But that might take certainly might be some years, and it might take some further developments in our law to allow that.
Thank you very much for that answer. Thank you very much, CJ.
Right. Commissioner Gotzel.
Thank you, Chief Justice, and good afternoon, Judge Savage.
Good afternoon.
I just wanted to follow up on the comment that the Chief Justice made at the start of your interview. If I understand correctly, I believe you were reluctant or not so keen to apply. Perhaps just advise the Commission why this is and what persuaded you to apply.
I had not completed a term acting, as I said to the Chief Justice. I had not as yet completed a term acting in the Constitutional Court, although I had extensive years of experience from 2015 in appeal courts. I had not written a judgment as yet in the Constitutional Court, and I had alerted the Chief Justice to this and said that I thought perhaps that I should not apply for those reasons. And the Chief Justice indicated to me that she thought that neither of those should prevent me from applying. I then said to the Chief Justice that my position unfortunately remained no, and that I would discuss it with my family. And I did discuss it with my family, and they were more enthusiastic for me applying than I was. And this is a nerve-wracking process to come to this commission. And this is my fourth time here, and I'm the mother of 3 kids. I'm a wife. I'm a sister. I'm a daughter. I don't really want to come here and then be criticized deeply for pushing myself ahead in circumstances where it was premature. And I think that was my reluctance. Of course, when the parties who did talk me around to it told me to do this, they indicated, well, I could serve 12 years, that I'm exactly the age to serve 12 years, that I have the experience, that I was an activist in my past life, that I did law for the reasons that I did it, and this is the court I should be in. And I then said, well, I haven't got a nominee. And then other people got a number of nominees for me.
Follow up? All right, you then, Commissioner Steinberg.
Good afternoon, Judge Savage.
Good afternoon, Commissioner.
I'm over here. You've given your reason why you were reluctant to put yourself up at this point. You've had time to reflect on it, and in particular, your reason that you had given yourself, that you thought it's premature at this point. You've now had time to reflect, and what is your view about your readiness and ability to, if you were appointed, to assume that position and to function optimally from the outset?
I have had time to reconsider my position. I've also had further time in the Constitutional Court. I've also been involved in a judgment that I'm writing, and in fact I have written my draft of the judgment, although I'm waiting for my colleagues to comment on my post-hearing note. I feel far more ready than I did at the point that the nomination went in, and in fact that was something the Chief Justice had said to me, that it would be easier, because by the time I was here in October, she was asking me in August, and so it would be a bit easier, and it's much easier. I think as far as my readiness in other ways, I am very deeply committed, and it is the reason that I studied law, to the transformation of this incredible country of ours, which has so very many problems. I think that we can use law constructively to achieve social justice and the kind of change that we want to see, all of us, as South Africans. We have a very young population. 60% of people under 30 are unemployed in this country. 95% of people who grow up in poverty don't break out of it in this country. Those are the stats that we're dealing with. We have 10% of people who still suffer from food insecurity. We've got very, very many and fundamental problems. And I see, having been involved in the drafting of the Constitution, I see incredible opportunity in the Constitutional Court to work on each of these and other issues. And I do see a role for myself in doing so if I'm wanted. If I'm not wanted, I'm equally happy to remain in the area of labour and in other courts to do what I can there in those courts, in furthering what I believe are the needs of our society, and assisting the judiciary in doing that.
Well, I do know that President Vulemela is waiting to pounce on you. Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Judge Savage.
Good afternoon, Commissioner.
Before we read too much, Judge Savage, into what you've just said, which is that you didn't consider yourself worthy of the position, isn't that classic imposter syndrome that you've described?
Absolutely. And if I may, I'll use this as an opportunity, because I know you've been canvassing the sexual harassment policy. And I think that I've been in the judiciary from 2012. I was very early on asking why we didn't have a sexual harassment policy in the judiciary, and it took our Chief Justice now to, within minutes of being in her role, to ensure that we have a sexual harassment policy in place. Equally, and that is such an important step forward in terms of setting the tone of zero tolerance to conduct that takes any form of a harassment in the workplace. But equally, I would like to say that many of us as women, and particularly some of the trailblazers, have faced an enormous amount of bullying in the judiciary. And I would like to see increasingly that a policy be developed which deals with harassment more holistically than sexual harassment. That's not to say that we shouldn't start with sexual harassment. In the labour sphere, we started with a code on sexual harassment. And recently, that was in 2005. In 2022, following South Africa's ratification of the ILO's Convention on Violence and Harassment, we then amended our code, and we put in place a code, that is, we as in the country. The code was amended to include harassment and all sorts of other workplace misconducts relating to harassment, but also including bullying. And I would just like to speak briefly to what the difficulty of breaking through glass ceilings sometimes is. When you break through a glass ceiling, you are accused of putting yourself ahead of yourself. So you're often treated very poorly in doing that. When I went to the SCA, I was treated very poorly by certain colleagues for doing that, for apparently jumping ahead of myself, although I had nothing to do with putting myself at the SCA. And those are very damaging experiences for people, because you do not want to be accused of such behavior when all you are doing is doing your job to the best of your ability. And of course, it's easy for people who don't experience that level of bullying in the workplace or generally in our society to say, oh, but come on, you're overreacting. Of course, you might think one's overreacting. It's a bit like white people saying that black people must get ahead in this country, get out of poverty. Well, it's a little bit more difficult. And if you have actually lived through it, you might have some personal experience that would allow you to then consider where one stands in it. So as far as putting myself further forward, I have been very concerned about the haters. And I have to say that I listened to the Taylor Swift song of, I'm not in the Swifties because I'm probably 25 years older than a Swiftie, but I listened to that song about the haters are going to hate, hate, hate. And I think women need to do that. I think sometimes women need to push themselves forward, but they also need to be supported in doing so. I thank very much my colleagues in the judiciary who, certainly on this decision, and I include the Chief Justice in that, who have unequivocally expressed support for me and pushed me forward to do so, despite my own hesitations, which I've described.
You mentioned the sexual harassment policy, and having worked through the policy, do you see any pros and cons to the creation of the gender desk in the office of the CJ?
I think that any advance is a good one. And so if the gender desk is going to help us, that's a good thing to do. I also think compulsory training and not voluntary training is a very important thing, and that's also included in the policy. So yes, I think the policy as it stands, yes, is a very good step forward. And we need to set a zero tolerance tone. When I wrote the judgment in Simmers in the Labour Appeal Court, I was criticized by academics for setting the bar too low, but on sexual harassment. And my response when I read those articles was it can't be set too low. It's an abuse of power in the workplace, and so is bullying. And in just to move back into the bullying issue in the judiciary, of course, one of the difficulties is we're A, not employees, B, we're appointed for life, C, it's a flat organizational structure until you are promoted to the next position. So whether you came in on day one or you're there in day one of year one or you're there on day one of your 20th year, you are earning the same salary in the same court. And that does have some difficulties and does pose issues. And I think raises important questions around the circumstances under which people dissent, when they're brave enough to dissent, and particularly for people who feel that they may be not supported in the environment, or B, that they will be criticized or that they won't be advantaged in any way further in the environment. So if there's an external structure such as a gender desk, that might be a useful way forward.
And finally, while the sexual harassment policy is very strong, comes down very strongly in favor of victims of harassment, it does also seek to balance that by focusing on the rights of people accused of harassment. Now, in an instant where we opt for an adversarial system to investigate complaints, do you think there's more that we can do to protect the rights of victims?
Well, I think it's important to protect the rights of everybody. I mean, we must make sure that if there are false complaints, that they are properly investigated and that they're properly. The difficulties often in these issues is it's a one-on-one, so that one is dealing with one person's version versus another. But so I think the first step is, yes, we need to protect the rights of victims. We must also protect the rights of those who may also be wrongly or falsely accused. At the same time, I think that part of a gender desk's role could be, in fact, to provide that sort of support, the kinds of support that perhaps I've received in proceeding with this application. and that the kinds of support that are needed so that people stand up and say, I have been the victim of sexual harassment. And I think that could be usefully done through that sort of a structure.
Thank you, Judge Savage. Thank you, Chief Justice.
Thank you, Commissioner Pillay. Is it follow-up? Okay. Commissioner Trollip, he raised his hand a long time ago. We've just been dealing with follow-ups.
Thank you very much, Chief Justice. Good afternoon, Judge
Good
Savage.
afternoon, Commissioner.
I noted the comments of the Chief Justice about your reticence to apply, and I'm sure you read the documentation related to your application,
I did,
including the Law Society of South Africa's comments,
yes.
and their perplexing recommendation that they're unable to recommend you. I just want to make a few comments before you respond. They go on to say that you had a record number of nominations, and I'm paraphrasing, and this doesn't reflect fairly on the nominee who seemingly might be a person who's supportive of social cohesion, and I think your role in the drafting of the Constitution and the preamble confirms this. Yet they say that those who rush to nominate their own judge seem to have an advantage over advocates who might appear, black advocates who might appear before you. Then the LSA goes on to say that you were previously nominated by a black female deputy judge president in one of your previous appearances. And they go on to say you are acting in the Constitutional Court, you're a judge in the Western Cape High Court, acting judge president of the Labour Appeal Court, and you have no reserved judgments and no part heard matters. Now, all of that would normally go with a ringing endorsement. I am concerned, and taking into account what you said about glass ceilings, about what your sentiments might be to that report.
I have to say, thank you for raising it, because I was absolutely amazed when I read it. I was also amazed to see the exclamation marks and etc. I didn't ask one person to nominate me. Those nominations were people who decided of their own accord to nominate me. They are women senior counsel in the Western Cape. The Western Cape has been notorious in its difficulties to transform that bar. And many of those women, and a number of them are black South Africans, they have strived endlessly to ensure with their colleagues, who are also on the list of nominees, to ensure that steps are taken to achieve the kind of transformation that is needed in that bar. When I started in 2012, I was the 13th woman ever to be appointed to the Western Cape High Court. I could count on my one hand the number of female senior counsel that there were at the bar. I could equally count at the bar in Cape Town. I could equally count on one hand the number of black senior counsel that there were. So there was a significant and serious problem in that bar. And over the last period of time, 13, 14 years, since that time, we have seen enormous strides taken. And I think that the nomination, in fact, reflects their view that I stand in support of their efforts to transform. Of course, that bar needs to transform further, but we need to credit transformation where it occurs and where steps have been taken to ensure, for instance, that women are able to access the advocate's profession equally, and so on. And that I think that I would describe, if I was saying to my children, that is tone deaf.
Thank you, Chief Justice. I just want to place it on the record that I found that LSA report perplexing and completely incongruous with the CV and the nominations and your own commentary. And I want to place it on the record.
We have it, Commissioner Trollip. Then it's Professor Marumahai. He raised his hand before you, Commissioner Mangena, as did Commissioner Moimang. We'll get to you.
I've already asked my questions, CJ.
You have?
Yeah.
All right. Then it's Commissioner Moimang before you.
Thank you, CJ. Good afternoon, Judge Savage.
Good afternoon, Commissioner.
So just one from myself in relation to the judgment that you raised as part of your contribution to jurisprudence, the one that deals with the Minister of Public Service and Nahau.
Yes, thank you.
Yes, I'm more interested in getting the the significance. What is the significance
That was a national.
of this judgment, given the fact that the last 5 years has been described more or less as the hallmark of tension between public sector unions and the Department of Public Service Administration in relation to public service wage negotiations and settlement agreements and payment of agreed upon increases. Thank you.
Yes, thank you, Commissioner. I put that judgment forward for a few reasons. The one was, as one will remember, that was a dysfunctional strike which included essential services workers and led to the deaths of a number of people seeking medical treatment in hospitals and clinics around the country. And I felt it important because it had dealt with issues relating to that strike and the sorts of the approach of the Labour Appeal Court to the strike notice was interesting, and also to the treatment of court orders as far as the police was concerned, because there seems to be an increasing view from that time and even prior to that time that the police don't seem to think that court orders mean anything other than a voluntary exercise in enforcement. And I made quite a clear comment in that judgment around court orders, it being non-negotiable that court orders are to be enforced. That judgment was heard on a Friday, and as you'll see on the Monday morning, we handed down judgment at 9 o'clock in the morning, and Nahawu was ordered to advise its members by 1 o'clock that day of the outcome of the decision. So I drafted that judgment over the weekend, and I just thought that it would also, for that reason, be an indication of my judgment writing, my approach to judgment writing.
Now, what about the non-compliance on the part of the Minister of Public Service Administration to adhere to the agreed public service wage agreement?
Well, we did make comments around that, and I mean, I did. And I wrote the judgment. In fact, I said to my colleagues, would they mind the judgment being in the name of the court, because it would be better that it came out. It'd have a stronger message if it came out in the name of the court as opposed to just in my name. And we made comments about that. I made comments around the role of the employer in negotiations as well, and particularly a state employer with so many employees. It's really very important that the state adheres to its obligations as employer, and that it ensures that it conducts itself in those negotiations in the manner that it's supposed to, and not to just bail on agreements which then create difficulties down the line.
Thank you, Justice.
And actually create the deaths of people down the line. You know, if we hadn't had that situation emerge, we might not be in in the same boat.
Thank you, Justice. Thank you, CJ.
Commissioner Mangena.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner Mangena. I sat next to you the last time I was at the JSC, sharing some jokes with you, but now I'm on the other side, so you can really go for me now.
Now, yeah. With what you have said earlier on in your interaction with the Chief Justice regarding the role that you played in the run-up to the finalization of the Constitution, there is a quotation that is attributable to Ernesto Che Guevara. It says that if you tremble with indignation at every injustice, then you are a comrade of mine. Do you know that? Have you heard of that?
Yeah, I've heard that quote.
Yes. Because with what you have done, you have really proved that you cannot tolerate injustice at all. And there is a judgment that you wrote, Ekruleni local municipality versus Salga. It's a judgment that dealt with sexual harassment, and I see you did not list it as one of the important judgments here. Do you recall that judgment?
Vaguely. I'm afraid you might have to remind me.
Yes, it appears you were ahead of your times in view of the sexual harassment policy that was passed, that was adopted by the Office of the Chief Justice. In that judgment, an employee of the municipality had made remarks to a member of the public, saying to her, "You look like you'll be good in bed." And that member of the public, who was not an employee of the municipality, reported a sexual harassment complaint at the municipality and wanted the municipality to enforce its sexual harassment policy and deal with that employee. You still don't recall that case?
I don't, I'm afraid.
And
Perhaps it's a symptom of how many cases
yes,
I've dealt with.
Then the matter came to you together with your two other judges at the Labour Appeal Court. And you said that an official of a municipality in the exercise of public power needs to respect members of the public, and in execution of their power, they've got to always be mindful of the policies that are applicable to them. It did not matter that that woman who was there to obtain a driver's license was a member of the public and not an employee of the municipality. You should have a look at that judgment.
I stand firmly by that sentiment.
Yes, and
And
that
if it's
judgment
mine,
was-
then that's good.
Yes, and it was written after the CIMA's judgment. So you were actually following up
Yeah.
on the CIMA's judgment. And I thought that that was an important judgment, very significant, and it registered with me as one important judgment that should not be downplayed. And in view of the sexual harassment policy that has been adopted, you were indeed ahead of your time. Thank you for that good judgment.
Can I comment on two things? The one is that I am very committed to the transformation of this country. I live in my own family, in a mixed family, with my children having to fill out forms as to what race they are when there aren't any of the races listed. I mean, surely after 30 years, we can start to deal with difference and an understanding of diversity. But that is one of the challenges I think we continue to face as we live in a country so wrecked by inequality and remain one of the most unequal countries in the world. But the other thing I'd like to mention is that I, in my own engagement with public service, had an experience this year where I went to renew a passport at Home Affairs, and I sat with people on the cement floor of a parking lot. In front of me was a farm worker, and behind me were 3 school children. We sat for 7 hours. I was writing a judgment on the floor, and I was chatting to the two people, the school children, and I was chatting to the farm worker. And we got to within 3 people of the door, and the door was closed because Home Affairs was closing. So we'd sat for 7 hours. And we can speak about Batu Pele and the treatment of our citizens and other people in their engagement with public services. And it goes for the judiciary as well. We must all get out of ivory towers and go and realize what it is for people out there when they engage with our public services. And so to the extent that that judgment covers something along those lines, that's a sentiment that I strongly share.
Thank you so much. My second and last one relates to Section 157 of the Labor Relations Act. And you are probably aware of the tension that has been there between the Labor Court and the High Court in relation to the issue of jurisdiction. And the latest judgment to have come from the Constitutional Court on dual jurisdiction was Baloyi versus Public Protector. The retired Chief Justice Zondo, speaking at the 30th celebration, said that the country has not had a final weight on the question of the jurisdiction of the labor court. Do you share that sentiment that the issue of dual jurisdiction has not been authoritatively decided?
I think that's right. I mean, if we create specialist courts, then why wouldn't we put issues before those specialist courts and engage the expertise that they have as far as is possible? For instance, if you take restraints of trade, if the labor courts are dealing with the restraints of trade, under what circumstances? We have got dual jurisdiction, which is sometimes a very uncomfortable fit. And there are areas where the Constitutional Court from Chirua, Fredericks, all of those early cases tried to deal with the circumstances under which one would engage what would engage the labor court's jurisdiction and what would not. But I think it remains an area which needs more work and possibly even statutory amendment.
Thank you, Chief Justice.
Commissioner Hassan?
Thank you very much, Chief Justice. Judge Savage, I was going to pose this a little bit earlier, but I think it's still necessary. In the Campbell versus Simmers case, but as well as a few others that I've mentioned, and I think Commissioner Mangena has also gotten to this point, you've written and spoken actually quite powerfully about dignity, consent, and power in the workplace. And as you know, obviously, the judiciary has just adopted its own sexual harassment policy, and it's been quite critical to reframe harassment as an abuse of institutional power and a violation of constitutional values, not just workplace misconduct. So my question then is, how do you see the role of feminist jurisprudence in transforming not only what we decide in our own judgments, but how we behave as a judiciary, particularly when it comes to power dynamics, collegiality, and the hierarchy that can often make it difficult to call out misconduct by peers for what it truly is? That's my first question.
Thank you for that question, Commissioner. I must tell you, when I grew up, I was an oldest daughter, and I know there are lots of jokes about an oldest daughter in a family. I was an oldest daughter. I had an academic father. And my parents never treated me in any way that made me feel that I had anything but the opportunity, I should push myself as far as I could go, that there was no constraint, no particular job that a girl should do, no particular subjects a girl should take. By the time I got into the workplace, I must tell you that changed, and it was rather a rude awakening. I suddenly realized that, having not seen any need to call myself a feminist because I apparently felt quite confident about my rights as a woman, I found that there was a very different reality when that came to bear at work. So to the extent that it's important to advance issues that concern women and feminist jurisprudence does this, it has an essential role to play. It pushes us outside of the boundaries of where we currently live into the boundaries of where we want to be as a society. We are and remain one of the most violent societies in the world, not in conjunction with remaining one of the most unequal. If we have 16 days of activism against gender-based violence, we should have a decade of activism against poverty, against gender-based violence, against the violence of children, against letting children grow up in circumstances that are simply unjust and uncalled for and unconstitutional. So we need to be pushed as a society, and a feminist jurisprudence does it. It's very good for us in the judiciary to have those perspectives brought to bear. And very often they are, through amici who come to present argument before our courts, in submissions that are made, if they don't in fact make oral submissions, and so on. But it performs a very important function and continues to do so.
So related to that, right now, I think we're seeing a whole lot of, not just young women, I'd say women in general, who are watching the judiciary quite closely, not only for its judgments, but how it's handling its own internal culture, especially given the Megenenge tribunal, but also many others that probably haven't come out in the public arena. So we agree that the policy is a step forward. but policies alone don't dismantle patriarchy. So the question really is, how should a feminist judge lead genuine cultural change within an institution where that hierarchy and that difference we've spoken a little bit about can sometimes protect those who are in power?
Probably by applying to positions like this that I said I wouldn't do and being encouraged by people to do it. That's one of the first steps, so that people in the judiciary can make the change they want to see. When I was at Bowman Gilfillan, I was the oldest woman with children, as I recall, in the firm. And I used to leave at 3 o'clock in the afternoon and then work in the evenings at home after my children had gone to sleep. And one young woman, both black and white, came to me and said, "How are you so brave, Kate? How are you so brave? How do you leave this workplace like this?" And I said, "Just follow me. Just pack your bag and follow me. That's how you do it." So I think you lead by example. And I think I have relied, certainly in the application for this, for the nomination for this position, I've relied on being led by example. And I think that's one of the first ways that one does it. And I think also increasingly is with the number of women who are now in the judiciary, we need to increasingly start to ensure that one provides the support and backing that is needed, that we take action where bullying occurs. I have reached out to the Chief Justice in circumstances where I had felt bullied, and I got a very, very supportive response. And it is exactly that kind of support that I think changes the institutional culture. And this is well before the Chief Justice was the Chief Justice. So I would support women continuing to do that in the judiciary, because that's what makes for real change. And I think for young women looking in at our judiciary, I hope that to some extent some of us might be able to be something of a role model. I accept that we are maybe 20 years older than the woman who might be critical of what's going on, but I think we need to hear perspectives, and we need young voices. We need to hear young voices. We are a very young country with young people being in the majority, and we must make sure that we remember and hear those voices, and that we are able to really give meaning to those voices, so that the Constitution and the constitutional projects not simply brought into the gutter of everything else that everybody's critical of the country. It doesn't mean that you can't be critical of the judiciary, can't be critical of the judgments of the court, that we can't try and encourage the court to take different and further steps forward. But it does mean that I think we need to be open as the judiciary to hearing the voices, particularly of younger people, and understanding the kinds of challenges they face. Have we really ever thought of the fact that 60% of people under 35 don't get a job, or 30? We've got some very, very significant difficulties.
Commissioner Steinberg, followed by J.P. Taleti.
Good evening, almost.
Good evening, Commissioner.
A comment and a question. The comment is that I was very moved by your letter of application, your letter of nomination. And that must be all the female silks in Cape Town, and it's a ringing endorsement.
Thank you, it is, and I'm humbled by it. I really am. I think it really is credit to them in large measure.
It is, and I think you've sat here today and spoken for them and for many of us.
Thank you.
I'd actually like to ask a question about the law. Section 172 of the Constitution, subsection 1A, we're talking here about remedy.
Yes.
1A is a must. When you find an action or law unconstitutional, you must declare it invalid to the extent of its unconstitutionality. B, however, provides a discretion, the just and equitable order. As a High Court judge, and with the enormous volume of cases that we know High Court judges have, would it be useful for the appellate courts to give more direction, more rules almost, on how you exercise that discretion?
Without a doubt. I think it's one of the areas that we are needing more assistance on. Remedy is such an important area. And it is also so important when looking at, for instance, issues such as the development of the common law and what that might look like, and finding what is an effective remedy, under what circumstances it's effective, in terms of how far its reach is and how it could perhaps be improved. So I think there's definitely more scope for expanding jurisprudentially and understanding of just and equitable.
The Constitutional Court tends to emphasize the case-by-case basis on which cases must be decided. And no one can ever take away the judge's discretion because the Constitution gives it to them. But I do, as an advocate, it's very difficult to ever advise a client in the field of administrative law, for example, what their prospects of success are. Because something can be invalid and unconstitutional. The challenge could be brought late, and it can still not actually be set aside. In that area, do you think it's possible to create guidelines, without removing a judge's discretion, create guidelines?
I think one can. I mean, if one looks at, I think one can slowly start to develop the law to work towards, in different cases, from case to case, what just and equitable relief might look like. Yes, there might be areas in which it's not able, it might be cases in which it's quite different from another case, but that doesn't mean that one can't develop a common thread of principle running through it. Mm-hmm. And I think that there is, I agree with you that my experience of being at the court is that one does get something of a feeling of a case-by-case basis. And I attended the Stellenbosch Labour Law Symposium colloquium this week on Thursday and Friday, and found it fascinating to not only engage with some of the drafters of the LRA and some of the members of NEDLAC, who are very critical of what the Constitutional Court is doing on labour law, but also with advocates who feel that on a case-to-case, case-by-case basis, they can't tell whether they're going to get leave to appeal or not, even in the Labour Appeal Court, and that this is posing some difficulty when they're trying to advise their clients. So, yes, I don't know how one solves that problem, but it's certainly, these are some issues that exist.
Well, in other jurisdictions, you do see quite hard and fast guidelines and rules coming down in judgments from the Constitutional, from the Apex Court.
From the Apex Court, absolutely.
Okay, thank you.
Thank you, Chief Justice, and good afternoon, Judge Savage.
Good afternoon,
yes,
colleague, LAC Judge, Commissioner.
Yes. I must say, the first question you have dealt with it, I've never known you to be someone to easily succumb to bullying. And I'm glad that you'll continue to fight it, not only for yourself, but other colleagues in the judiciary. But something that you may have also dealt with, but I don't want it to be left open. It might be as if it's corroboration of something that was raised by Commissioner Trollip. We have the letter from the Black Lawyers Association, which says that we think that the experience of the Constitutional Court, even as a legal practitioner, does not appear to be significant. Hence, she does not have many cases that have appeared in that court. We think that she could benefit from some stints at the Constitutional Court in an acting capacity. And in conclusion, they say, we do not support her for appointment in that court, given her lean experience of that court, even as a practitioner. May perhaps want to comment on that in addition to what we have said before.
Thank you, Judge, President, Commissioner Tlaletsi. I was disappointed to receive that comment, firstly because it's factually inaccurate. I'm acting in the Constitutional Court. And secondly, perhaps more so because in the past the Black Lawyers Association has in fact supported my candidature for various courts. I reached out to my colleague who's the Judge President of the Western Cape, and she, Judge Bokwana, And she indicated to me that I shouldn't take it personally, that she was also not supported by the Black Lawyers Association when she was appointed. And so we had a bit of a laugh about it. But the point is, as far as the Labour Appeal Court is concerned, many of my judgments have gone to the Constitutional Court, and some of them have stood the test of time. That I have had various experiences in the Constitutional Court in my practice, and I have been involved in these areas. I'm sorry that the Black Lawyers Association feels that, but I think that I would bring unique experience to the Constitutional Court with my almost 10 years experience in the Labour Appeal Court as a specialist court. There's limited Labour appeal experience in that court currently, and I think it would be a valuable addition. One, and two, I think I bring my more general experience and outlook on life and my approach to transformation in this country to that court that I think would stand me in good stead.
Thank you. Thank you, Chief.
Well, you are in very good company, Justice Savage. I never enjoyed the support of the BLA, and I was their member when I was still in practice and did a lot of work for them. So there you have it. Is the follow-up, Commissioner Ngaitok?
No, not on the BLA. It's a follow-up on the questions that were asked by Commissioner Steinberg. Good afternoon, Judge Savage.
Good afternoon, Commissioner Nkatobi.
Very, very nice to see you in that position, despite your own apparent reputation. So the theme of your sort of legal presentation has been around inequality. And your commitment to the constitutional project, as you call it, in the rule of law, but primarily to solve the problem of inequality. But the difficulty is really, what is the jurisprudential basis for doing that?
Well, that's some of the criticism of academics, saying that we're not developing equality jurisprudence. What we're developing is jurisprudence around rights such as dignity and other rights on which we're then hanging constitutional relief given in particular socioeconomic rights.
Yes.
So I think we do need to give more guidance on what the substance of equality is. Bearing in mind, of course, that often those who challenge the inequality provisions are often the people we're not intending to have use them to their advantage, like affirmative action legislation.
Yes, yes, and I think we both agree that that's something that should be done, but the question is, what is it? What does it look like? Does the Constitution have an economic vision? Specifically, a vision about economic equality? Where are we going to find it? Is it in Section 9, in Section 26, in Section 27?
I think you find it first in the preamble. I think you find it when you say that we, therefore, through our freely elected representatives, not only heal, which we haven't actually done, as I said earlier, we lay the foundations for a democratic and open society in which government is based on the will of the people and every citizen is protected by law, and that we improve the quality of life of all citizens, free the potential of each people. That's the first place that we find a kind of reference to improving the quality of life. And then you take it through from there into the provisions of Section 1 onwards, those foundational provisions, which guide what kind of a society we're trying to build, and you then build it through into the Bill of Rights. And I think that one needs to more actively deal with the rights in the Bill of Rights to build the jurisprudence around building an equal society. We cannot, and this Constitution can't possibly be a transformative one, if we are going to permit the rampant inequality that currently exists in this country to continue. So we have to use, I think that the consensus, the social compact that we arrived at is in many ways fit for purpose. It does need development. It may need amendment here and there, but I think that it is fit for purpose, and it should allow us to use the courts to drive that process of building a more equitable society. Whether it's through land, whether it's through property, whether it's through access to resources, whatever it is.
Yes. One of the clearer provisions is Section 25. Not so much the land provisions, but the property provisions. That if you read that section properly, what it is trying to provide for is property equality. And the main feature of dispossession in this country since the arrival of the whites in the Cape was land. And if you want to resolve the problem of racialized inequality, you have to dismantle the property ownership. And that's the fundamental reason why we have a constitution. So that's the one argument in favor of the approach that you've articulated today. The other is that actually the constitution decided not to deal with the economy at all. And in that sense, it left it to the legislature to pass acts of parliament on a issue by issue.
Well, on the issue by issue, if you look, for instance, at competition law, the Competition Act, it is an attempt to provide a regulatory regime for certain areas of economic activity. It does reference workers, but certainly, and I think what it's trying to do is achieve a more equitable distribution or access to resources in some way. But yes, some of that law could go further. As far as the property clause is concerned, well, if you're asking me if I'm a hardline, I probably say I'm a social democrat, and we can find ways to find within a social democracy that in the way that some in my family might say they're democratic socialists. But what one can do in the society is find ways of using the constitution to build the access to resources that we want. We tax so that we can build access to resources. What we need to stop is people stealing the money that we have. We also need to make sure that we are developing and policy from a governmental perspective that sees wide-scale transformation. Whether we take a Singapore approach where we force neighborhoods to integrate, whether we need to do something slightly more severe than what we're doing now. I'm not sure that it's for the courts to necessarily come up with a policy, but I can totally accept that we need to do something more severe than where we are. If we are going to build a society that sees is good and is one that is fit for purpose into the next century.
Yes, I mean, the reason why Section 25 is an easier section for economic equality is because it gives the power to the state to expropriate property for distribution. There is no other comparable section in the Bill of Rights that entitles the state to take something that belongs to a different person and give it to someone else in order to pursue the public interest.
And that provision hasn't been used. I mean, it's been used so little. When I had a debate with a colleague 10 years ago who said to me, this constitution isn't good for purpose on the property issue and on land rights and so on. And I said, but why don't we use it? Why don't we use, this was one of the last clauses to be negotiated. There is no right to property. It was one of the last clauses that, with the right to lockout and with the education rights. Perhaps education has been the easiest of them. The lockout certainly hasn't been an issue of any moment. It seemed to be far more of a political issue at the time, but it's not really become an issue of any moment. And the area of property, ironically, is one, although it was hotly contested, in which the state has taken so few steps to actually implement in terms of this constitutional provision. So it can do so.
Well, some of us are wondering why the government is not expropriating land to give it to people who don't have it. There is a representative of the executive who sits on the JSC.
Well, of course, don't let me be understood, please, Commissioner Nkatobi, to be saying that I sanction wide-scale, uncontrolled, unconstitutional conduct in relation to distribution. But I am a firm believer that we, and I think most right-minded South Africans across the racial spectrum will agree, and the class spectrum, will agree that we need to do something very, very serious to deal with some of the pressing issues facing our country. And we will not be able to let children grow up in peace with access to proper resources if we don't do it, with access to jobs, with access to housing, with access to appropriate levels of water, food, etc. We won't be able to do it if we don't all commit ourselves to being part of that constitutional project. And that includes government. Government's done a lot in very, very many areas. The area of the world from which you are saw immediately after 1994 an enormous electrification campaign which does turn people's lives around, which does allow access to some level of engagement, certainly even now when we see children trying to study under candlelight still. But we need to do more. And there are no two ways about it. And the courts need to be part of that project.
Would you agree that there is an implicit provision in the Constitution, in the Bill of Rights, of the right to economic equality?
Yes, I think social justice must mean economic equality.
Yes. In that sense, it's explicit.
I think so. I can't see how social justice can mean anything other than allowing people to engage equally in the economy. If I have a child who is a middle class child who goes to a government high school and then engages in the economy, that child must have that child and a child who comes from Khayelitsha, from a single family where they are living in an informal settlement, that child must be able to engage equally in this economy. And we need to take steps to ensure that happens. The interesting factors, and we can have a long conversation about this, but the interesting thing that came up at the colloquium this last week was the drive to do internships and learnerships, and what that's really causing. Is that really manifesting as jobs? And the stats are not good for it. So what we're seeing is that we'll have matriculants coming into the workplace at a very low level on an internship. But at the end of that year, the next person will come in because it's good for the company to just take the next internship grant, and so they go on to the next person, and that person just can't engage in the economy. So where's the economic equality there? Where do you create people able to access equal jobs?
Yes, so I think in some, maybe you have
We
finally
did
answered.
say just two questions, Commissioner Nkaitobi. It is a riveting and critical topic, I admit, and but then we could go on and on and on, and teasing just one question into 1,000 different directions does not make it one or two questions.
This is really the last comment.
Let's close it off, please.
This is just the last comment, nothing else.
Okay.
So Justice Savage, you would say that the commitment to social justice in the Constitution is really a commitment to economic equality?
I think so. Building it. Certainly we must strive towards it. Like I would think the kind of economic equality of arms that you would see in other more established economies. For instance, if you went to the known social democracies in the world, you would have that kind of access. Yes, I'd say so.
Thank you, Chief Justice.
Commissioner, President Willemette.
Yes, thank you very much for the opportunity, Chief Justice. Justice Savage, just one last point. You heard the Chief Justice mentioning that I am very, very eager to have you at our court. She knows this because I did contact the Judge President of the Western Cape Division to ask her to release you, but I was too late because the Chief Justice had already snapped you. But the other thing that I wanted to mention is I heard you regarding the concerns that you raised regarding bullying and so forth. And I very much appreciate your zero tolerance towards that. And I happen to serve on the Council of SAJE, the South African Judicial Education Institute. And every July of every year, before that, in July we have seminars, but before July, the CEO, Dr. Musho, usually approaches all the heads of Koto to ask whether some of their colleagues cannot present at the seminar. I would urge you to consider making a presentation for SAJE on the Judicial Code of Conduct, because if you have a look at Article 11 thereof, It spells it out very, very clearly that every judicial officer is expected to foster collegiality, meaning when you are collegial to your colleague, it's not a favor that you are doing, you are actually duty bound to do that. So I'm just saying, please consider raising your hand for that, because I think it would assist very much in the department that you alluded to.
Thank you. I will do so. Thank you.
Thank you, CJ.
Commissioner.
Thank you, President, and I support that motion. Minister?
Thank you very much, CJ. Good afternoon, Justice Savage.
Good afternoon, Minister.
It's quite refreshing to sit here and listen to you. Interesting having read your CV and looked at your journey, but I think more interesting listening to you. And I do think that many women, when they hear you, they echo most of your sentiments, but are proud to see how you can stand your ground.
Thank you.
That is appreciated. And having worked, what inspires me, and I think this is one of the things that one looks at it, having worked with the Constitution, one part of what we talk about in terms of the preamble of the Constitution, it talks about healing of the past. So it goes to the issues of restorative justice. And from where you're sitting, as a person in the bench, and I've listened to you, even the issues that you talk about as advocate, Ngatobi was a commissioner, Ngatobi was saying there's a representative of the executive here. Quite a number, do agree, and a lot needs to be done to ensure that we can secure our children in the country and the future. Do you think that there is a role that the judiciary can play, and what can there be a role in terms of around dealing with healing of the past and restorative justice?
Something that has really troubled me over quite a long time, because I in fact started to do some research on what happened in Nazi Germany at the end of World War II in terms of that population and how one built a common consensus. And I've got a lot of views on the issue. There was paid for by the Allies in the end of World War II, there was a public education campaign around healing that society. And I think we perhaps have not done enough. I think the fact is that it's difficult to heal a society which remains that is not integrated, in which we're all living in our own little worlds, in which language is an issue of difference, of significant difference, in which our children are going to schools and learning languages and not able to speak them. At the end of how many years of learning isiXhosa or isiZulu, they can't speak isiZulu or isiXhosa, and they can't speak even Afrikaans if they learned Afrikaans often. And we need to really look at how we as a society engage with healing into the future. Because what we've created, they did not know of all of the protests that were going on. They did not know of a lot of what was happening in the country. They were born after that time. They heard about it. But what they see is the effects of it. And we really need, as a society, to take some steps. So what can the judiciary do in taking those steps? I think where possible, where it's open to the judiciary, we can take those steps. But I would see it being led essentially by government. And perhaps through our schools, and through our neighborhoods, we need to diversify our society. We need to open up our economy. We need to make people able to get jobs. We need what everybody around the table knows. But we need to take active steps to achieve it so that we can build the society that we are proud of into the future. And I think, when we watch rugby, I didn't used to watch rugby, but I now am a great rugby fan. And it just shows you what happens as you feel a team is diversifying and so on. And one takes rugby as looks at the rugby team. If one recalls about 20 years ago, there was a huge hoo-la-la about the fact that there were going to be quotas imposed on the rugby team, that they had to diversify. And then what happened was that you had clever people involved in rugby who made sure that they did diversify, and they did. And so we've got a team that apparently all of us can now support. Well, we need to do the same in the rest of our society. We need to make sure that we are all growing up in neighborhoods where children don't they have friends of all hues who come from all sorts of backgrounds, who are different religions, who've got different languages, and so on. And the judiciary needs to make sure that that sort of healing is able to happen by the kinds of judgments and orders that we make.
Thank you.
All right, we finally reached the end of your interview, Justice Savage.
Thank you.
Thanks again for coming here this afternoon. I think it was well worth it. And you've certainly given me, I can only speak for myself, you've given me a lot of food for thought. I've heard the interesting things you've raised. I'm listening. We'll talk more. Thank you very much.
Thank you very much. Thank you, commissioners. Thank you.